Good morning and welcome to the 10th episode of Coffee with Casey. I'm Casey Hicks, a partner and the office managing attorney here in Chicago at the offices of Weltman. This morning, I'm sipping on a delicious caramel cold brew because it's very hot and humid here today. I'm always interested in what others are drinking on these early morning webinars, so please feel free to put your choice of drink in the question feature so we can see what everyone's drinking today. As I mentioned, this is our 10th episode of the series, and I think we have a record number of registrations and hopefully attendees today. I appreciate everyone registering and participating by asking questions. Today, I'm joined by my fellow partner and Bankruptcy Group Chair, Scott Fink. Welcome, Scott. Good morning.
Good morning, Casey.
And Scott's going to go over some bankruptcy hot topics with us this morning, like how a bankruptcy filing affects creditors' rights and ability to recover collateral that secures a loan, as well as repossession issues that pop up once a bankruptcy is filed. Before I get started, I'm going to go over the general housekeeping matters that we have, like how I should control the PowerPoint. So like I said, this is interactive webinar, so please feel free to type your questions into the questions feature. We will try to answer all of the questions today during the presentation. If we can't get to all of them, we will reach out afterwards. And also this webinar is being recorded and a link to the recording will be sent to everyone that registered following the webinar. At the conclusion of today's event, you'll also get a brief survey that will pop up on your screen. So please share any feedback that you have from today's session. And if there's any future topics you'd like to see us cover in this webinar series, please let us know. We are scheduled for 30 minutes today, so we'll go ahead and we'll get right to it. Welcome again, Scott. If you want to tell the group a little bit about yourself.
Oh boy, about myself. All right, so I do head up the firm's bankruptcy practice. I've been with the firm for almost 20 years now. I'm nearing my 20th year. Handle all chapters in bankruptcy, from simple sevens where we're recovering collateral or getting reaffirmations, up to some pretty complex Chapter 11 matters. Obviously very familiar with the issues that we're going to be discussing today, which are near and dear to many of our clients' hearts, which is how can I get my collateral back? Oh my God, a bankruptcy's been filed. Either we're holding on to the collateral, we don't want to give it back, or we want to get it out of the bankruptcy. We hear it all the time, and we feel your pain. We understand that these are sensitive issues for you guys. I'm originally from Queens, New York. I do have hobbies, but Pearl Jam is clearly one of the big ones. You can see this way and this way. I would pan the whole thing around my office. We're a few weeks away from moving, but these are the last things that are going to go. Will be my posters, which I will be adding to later this fall. I'll be at Wrigley again.
Oh, very nice.
For a show there, and I will also be at Fenway in Boston for a show.
Oh, that's great.
You're do the baseball tour.
My Taylor Swift.
Yep, exactly.
All right, so here's our 3 hot topics for today. So Scott, let's jump right into the first one.
Okay. So, there we go. Get a little coffee in me. All right. So what really, obviously, everybody wants to know how first of all, does a bankruptcy filing affect the creditor's rights and ability to recover the collateral that secures the loan? So the overarching big thing we have to focus on is, why is it even an issue? Why does bankruptcy even matter for recovering collateral? Why don't you just be able to go get it? And the dreaded words automatic stay come into play. The automatic stay is something that takes effect immediately upon the filing of a bankruptcy. It is set forth under Section 362 of the United States Bankruptcy Code, and it basically lays out a laundry list of things that a creditor or parties cannot do with regards to the debtor and or the debtor's collateral. And it takes effect, again, immediately upon the filing, whether you know about the bankruptcy or not. The 2 big ones for us to really focus on today for this topic are the fact that it halts the ability of a creditor to either initiate a new lawsuit or to continue on with a pending lawsuit. And it also halts any action by a creditor to obtain possession of property of the estate, meaning property of the debtor that they own, that is titled to them, that they're in possession of on the date that the bankruptcy is filed. So those are the big no-nos for today's topic. And as I said, you're subject to the automatic stay as a creditor, whether you know the bankruptcy was filed or not. However, I will soften that a little bit and say, of course, if you have a customer who doesn't tell you that they filed bankruptcy, and it's not like you get an instant message saying that a bankruptcy got filed. It takes hours or even days, sometimes weeks, before you may get notice through the mail, or maybe the debtor may reach out and give you the information, or their attorney. But if you repossess a vehicle and the debtor has just filed bankruptcy and you don't know about it, you're not going to be sanctioned for that. That's not something that you can be monetarily sanctioned for. The debtor may threaten that, and you may have to hire an attorney to defend that, but there are defenses. If you didn't know about the case and you had no ability to know about it, you will probably have to give the vehicle back ultimately, and we'll get into that through this. But the one thing I can definitively tell you is you're not going to be sanctioned and have to pay damages to a customer if you had no ability to know of the bankruptcy filing at the time that you repossessed the vehicle.
Okay, we do have our first question that came in, Scott.
Fire
Are
away.
there any exceptions to the automatic stay taking immediate effect upon filing? Maybe a repeat filer or something like that?
Yes. So there are some exceptions, and the repeat filer is a good one. If somebody files 2 cases that get dismissed within a calendar year, and then a 3rd case gets filed within that same calendar year, the automatic stay does not take effect. So if you are a creditor in that situation where you've got a customer who is now on bankruptcy number 3 within a 365-day period, you can continue on with your repossession, take the vehicle to sale. It doesn't mean that that the debtor might not file something in the bankruptcy that you will have to respond to. If they seek to impose the automatic stay, you'll need to hire counsel to defend it, but you don't have to stop your actions, whether it's a lawsuit, whether it's repossession, things like that. Okay. There are other things that aren't necessarily relevant to today that the automatic stay does not halt, and that would be things like child support enforcement, spousal support enforcement. There are certain things that, criminal actions, those are going to be allowed to continue on regardless of whether a bankruptcy is filed and the automatic stay takes effect.
Okay.
So now the question becomes, of course, we've got this automatic stay. Scott just told me I can't do anything. Well, it doesn't mean you can't do anything. It means you need to have the automatic stay lifted or removed before you can take actions. And depending on which chapter of the bankruptcy code your customer files in, there are different options you have to go ahead and get that automatic stay removed to do what you need to do to get your collateral. So first, in a Chapter 7, you can either file a motion with the court seeking relief from the automatic stay, or, and we have plenty of clients who do this, you can wait 45 days after the initial meeting of creditors is set, sort of count your days, and if the debtor has not followed through on their statement of intentions, which is something they fill out at the beginning of the case, stating that they're either going to surrender a vehicle, reaffirm it, or retain and pay, which really is not an option. So it's really, are they going to surrender it, are they going to reaffirm it, or are they going to redeem it by paying you a lump sum? If they don't follow through on those intentions within 45 days, the automatic stay falls off automatically. We have lots of clients who decide to just use that automatic fall off, for lack of a better term, and they don't file a motion. But we also have lots of clients who say, we don't want to wait, because it's not 45 days from when the case is filed. It's 45 days from when the meeting of creditors date is set for. So you're probably talking more like 60, 70,
okay,
even 80 days before that automatic stay will just drop off on its own. A lot
So
can happen.
is the meeting of creditors usually how soon after the filing is the meeting of creditors
So the
usually?
media creditors is usually a 40, it's at least 30, it's usually more like 45 days after the case is filed. So
Okay.
yeah, you could be looking at 70, 80, 90 days.
Okay.
And as you can imagine, and I'm sure everybody listening right now has horror stories of their customer either absconding with the vehicle, allowing the insurance to lapse, the vehicle is involved in an accident. There's a million, they damage the vehicle out of spite. They take tires off, they all kinds of things. So it is a dangerous game to play to just say, I'm going to wait 60, 70, 80, 90 days and then send out my repo guy and have the surprise of either the vehicle's not where I thought it would be, or the vehicle's not in the condition we thought it would be, or it was in
Mhm.
an accident and the guy dropped the insurance 3 months ago. So we have that's the rationale behind saying, you know what, let's be forward leaning, let's get our motion filed as soon as possible, which I know I'm cheating here because I know there was a question that was submitted early on before the webinar even started, asking sort of how soon can we or should we file a motion for leave from stay. I might as well hit that now and
Go right
say,
ahead.
yeah, in a chapter 7, which is what we're talking about now. Look, if your customer is delinquent on the loan, that's number one. If they're delinquent by more than, you know, a 14 or 20-day period, definitely you want to file a motion for leave from stay. If they're just lagging a little bit on this payment and they've been paying like clockwork and their statement of intention says they're going to reaffirm, that's a different story. Then I might say, let's go ahead and reach out to their counsel, determine what their intent is. Maybe we don't want to be too rash and just go pop the car. If you have reason to believe or you've gotten notice that their insurance has lapsed, I would not wait. I would go and get that car through a motion for relief from stay and not wait. So that would be my take on it. Now we'll flip to the chapter 13. It's a good segue. Chapter 13 is a totally different animal because for those who don't understand the difference between 7s and 13s, a 7 is essentially a liquidation. What it means is your customer goes into bankruptcy and avails themselves of the ability to get a discharge of their debts, but in exchange for that, they are opening themselves up to and making all of their assets available to the trustee in bankruptcy who's overseeing the case. That trustee's job is to parse through everything they own, determine if there's anything that has any value that's not encumbered by a lien or has equity over and above the lien, turn that into cash and pay unsecured creditors with it. It's a much shorter process. It's again, you could be talking about 100 or 120 days from start to finish where your customer will get a discharge and that case will be over. And that's the only means of repaying creditors is if there is equity in assets or unencumbered assets that a trustee can sell and then pay creditors. If you have a customer who basically has nothing or has things that are either encumbered by mortgages, liens, and the like, and or there are exemptions, which every state has exemptions for different types of assets. Your certain amount of equity in your home, equity in a car, money in the bank that a creditor can't really get at. So that's factored in as well when you figure out what can a trustee grab and sell or turn into cash and give to unsecured creditors. So that's the only means by which you can pay creditors in a 7. And the trustee has the right to, sell real estate, sell property. They have the authority to
Mhm.
do all that. In a chapter 13, the burden really and the job shifts to the debtor. The trustee in a chapter 13 is solely administering the plan that the debtor has set forth, and the debtor is proposing a plan to repay creditors over a period of time, anywhere from 36 to 60 months, generally speaking. And the amount which the trustee, or excuse me, that the debtor will repay to creditors is somewhat related to a chapter 7. You basically have to do a hypothetical chapter 7, pretend that somebody's in a 7 and say, what if we liquidated this person tomorrow and took everything that's encumbered, put that in one pile, everything that's unencumbered goes into this pile. How much did that add up to? I have to pay my unsecured creditors at least that much money in a Chapter 13. I also have to pay whatever my disposable income is, taking into account, here's my expenses, here's my income, whatever's left over in a month, I have to pay that for the period of 36 to 60 months. But the bare minimum an unsecured creditor will get in a 13 is going to be that hypothetical liquidation scenario. What they would have stood to lose in a Chapter 7, they got to pay that in a 13. So back to the point, which is in a Chapter 13, you have to look at their plan. They're going to propose a plan. They're going to say, I propose to pay my secured creditor on the car this much money with this much interest. Or they're going to say, I want to surrender that car. Or they may say nothing. They may be silent on it because they either didn't know or they forgot to tell their attorney. It is incumbent upon you as the creditor to review that plan and get an objection filed if you don't agree with the treatment. If you think that they're undervaluing you, if you think that the interest rate is too low, if they didn't mention you, you need to take action on that. A Chapter 13 plan can provide for surrender of your vehicle or your collateral, and it usually will not take effect until the plan is confirmed, which takes time. You could be sitting there for, again, 60, 90, even 120, you could be a year waiting for a plan to confirm before that surrender takes effect and the automatic stay falls off. So
can you, sorry, so a question came in. Do you have to wait for a confirmed plan in a Chapter 13 before you can file a motion for relief?
Perfect question, and the answer is no. You should file a motion for relief from stay. If there's a surrender scenario, file it immediately. Once you see that the debtor's telling you they want to surrender the collateral, do not wait, because Chapter 13 plans take a long time to confirm. If they are providing for you in the plan, then they're saying, I'm going to pay you X amount per month, on this, and you're basically, it's a good proposal. They're paying you everything that you're owed, and they're paying you your interest rate or close to it. You'll ultimately be bound by those terms, and if you tried to file a motion for relief from stay and just say, well, I want my car back, you're going to lose on that motion. What you are entitled to, though, is adequate protection payments to cover you for the period from when the Chapter 13 is filed until when the plan confirms. An adequate protection payment is not necessarily, and usually isn't, your monthly contractual payment. What it is an amount to compensate you for the depreciation on your collateral during that time on a monthly basis. Typically, if you want to know the number, figure 1 to 2% of your balance on a monthly basis is what you are entitled to, and you can and should file a motion. If they haven't provided adequate protection, you can ask for adequate protection.
Okay, another question, Scott.
Yes, bring it on. Bring it on.
Is there any recourse if a customer fails to perfect a lien on a vehicle and then files bankruptcy?
All right, say that again. I'm sorry. Is there any recourse if they fails to perfect the lien?
Correct.
Okay. So you're going to be in a world of hurt in those situations. If you don't perfect your lien and you're not, it's one thing if you fail to perfect it, you have 30 days. And if the bankruptcy filing interferes with that, if it falls within the 30 days, you can still perfect your lien. But if your 30 days has run and now the bankruptcy is filed, you have an unencumbered asset is what you're looking at. And if you try to perfect your lien, back to the original, you're violating the automatic stay. You're stuck. Your recourse is going to be against your dealer ultimately for not getting this done. If you have that's always a thorny situation for lenders, because they want to go against their dealers. This is their source of business. They're funneling loans. I get it, but that is ultimately your recourse.
Okay. Now, once a motion for relief order is obtained on a vehicle, what type of cooperation, if any, does debtors counsel have to provide regarding the location and surrender of the vehicle?
So the sad answer is not much. Once that relief from stay order is in place, bankruptcy courts take the position, if you are having problems getting your vehicle back, go to state court. There are plenty of means through replevin, through debtors exams. There are ways to drag a debtor in and get the information you need. But bankruptcy courts take the position, once the relief from stay order is granted, this car or this collateral, it's no longer property of the state, and I no longer have jurisdiction, nor do I want to have jurisdiction to help a creditor go get their collateral. It sucks, but that is the reality. That being said, we at Weltman always take the position, let's use the bankruptcy while we can. And look, by and large, debtors' attorneys are cooperative. I don't want to say they're not. We try to ask on the front end, whether a client is asking for relief from stay, whether they're asking for a reaffirmation agreement, whatever, we want to get in front of that debtor's attorney. And if we have to go to the meeting of creditors, we'll do it there. I want to know, where is my collateral? Is it insured? Who is it insured by? And will you voluntarily surrender it? You know, we have plenty of clients who will provide us with, or we'll create for them, a voluntary surrender form that will have the debtor and the attorney sign, and it gives the creditor the ability to go and pick up that vehicle or effectuate a voluntary turnover of it even before the motion for relief from stay is filed or granted. It gives everybody that comfort level to go, hey, wait, if you can't complain that I violated the stay if you sign this form saying I'm giving you permission to come get the vehicle now. So those VSFs are very useful. Does it have any legal effect? No, but it makes everybody feel better. And it would be very difficult for an attorney to turn around and try to sanction you for taking a car from somebody if they and their client have given you permission to do so.
Okay.
Yeah. So
thank you for that, Scott.
Yeah.
We'll jump over to topic 2 regarding repossession, which we kind of touched on a little bit already, but
yeah. So this is the big piece I always want to impart on people. Historically, you as a creditor, if you refuse to return a repossessed vehicle or other collateral when the bankruptcy had been filed, you did open yourself up to sanctions for a stay violation. That was always a thing. And really the rule of thumb was, when a bankruptcy is filed, my answer to clients was always automatically just give the thing back. Don't even ask questions. You don't want to deal with getting in front of a judge and arguing why you refused to return it once you knew that the bankruptcy was filed. That all changed with a Supreme Court case, City of Chicago versus Fulton, where the City of Chicago was going around popping cars for, violations, whether they were, moving violations, parking meters, and these cars were all sitting in impound. And ultimately, there was a big suit that was brought against the City of Chicago. The Supreme Court ultimately ruled that a creditor can retain possession of those repossessed vehicles even when the debtor files bankruptcy and they say, give me the car back. You can't force them to give it back. The rationale was that the holding on to the vehicle that you've already repossessed before the bankruptcy, it's not an act to exert control over property. It's just maintaining the status quo. Now, I don't want everyone to get excited and think, well, I can just, thumb my nose at every debtor who says, give me my car back. It's a very limited situation. And yes, you don't have to give it back. We at Weltman are not going to tell you that that's the best practice. What we at Weltman will tell you the best practice is, use that case law to your advantage and make sure that you require, especially the Chapter 13, where they're providing for you in the plan, demand proof of insurance at a minimum. That is the thing I would do. Now, what that City of Chicago versus or Fulton, what that case did not say is that if a debtor files a motion for turnover, that you still don't have to give it back. You do have to give it back when you have a court order telling you to give the car back. It's just saying a mere filing of a bankruptcy means they can't compel you to turn it over. But if the debtor turns and make the next step of filing a motion asking for the vehicle back and a court grants it, you have got to turn it over. Do not try to challenge the court on that. You will not like the result. But again, the best practice that we have decided on based on this case law is, let's use the case to our advantage. Make sure that the debtor either provides for you in the plan, and both provides for you in the plan if it's a 13, and provides you proof of insurance in a 7 or a 13. Because if we have reason to believe that vehicle is not insured, I'm not big on giving that thing back, 7 or 13. So in that situation, I would get that over to your attorney ASAP. Don't return the vehicle. get your attorney involved. They will reach out to the debtor's attorney and say, we're not giving this thing back if they don't have insurance, and we're filing a motion for relief from stay immediately. So that's how we would interpret how you want to deal with the city of Chicago versus Fulton.
Okay. And we have just about 5 minutes left, Scott,
Yep.
so we'll just have to quickly go
We'll
through
zip
our
through
last
this.
topic for the day.
Not a problem. All right. So actions required in bankruptcy, the actions which, and required is a strong term for some of these, but which we recommend you take before you get possession and liquidate. Obviously, we talked about a motion for relief from stay. There is also an extra step in certain jurisdictions, the Southern District of Ohio, where I'm north of, but I'm in Ohio, trustee abandonment. Certain jurisdictions break that out into two things. You can get relief from stay, but because there's a trustee in a Chapter 7 who has control of all the assets, unless and until that trustee abandons their interest in the vehicle, you should not go repossess it. So it's automatic in a Southern District of Ohio motion. We incorporate both things. They're separate documents. The trustee signs off on an abandonment, and we're good to go. But there are a select number of jurisdictions that treat it kind of as a two-pronged, not just relief from stay, but abandonment as well. The voluntary surrender form we talked about, it's not required. You're not going to find that anywhere where the bankruptcy code says you have to or should. It's something, it's been a best practice, it's been developed throughout time by creditors counsel and creditors to just try to smooth the process of not waiting for that relief from stay to be granted, and also to document the fact that both the debtor's attorney and the debtor are willing to give you possession of the vehicle, hopefully before you even get your relief from stay. Plan objections we talked about, very important. We glossed over the fact that, there are ways that you can be treated improperly in a plan that you need to look at. They may try to cram down your value. They may try to cram down your interest rate. Things like that, you got to make sure you're looking at and you're objecting to protect your rights. And you also obviously want to see if they're proposing to surrender, that's great. Don't wait for the plan to confirm. You need to get a motion for relief from stay filed. Motion to dismiss with in rem relief. That's for the repeat filer situations where you've got someone who keeps filing and stopping you from taking possession of your collateral. You can get a motion to dismiss with in rem relief, which basically says, not only is this case dismissed, but we want to take this order and we want to have it apply to our collateral. It mostly works with a real estate situation with foreclosures. You can file that order with the county, and basically it's on there like a mortgage, and it runs with the property. So even if they give the property to another family member and deed it to them, they can't have that family member file bankruptcy and then stop the foreclosure. So it's just an interesting little, it follows the property wherever it goes. And then finally, the attendance in the meeting of creditors. As I said, we often will go for our clients to get that information on where is the car or other collateral located right now, and we want proof of insurance. We want it now. And if you don't physically have it, tell us who the policy, who's the insurer, and then get us the policy information when you leave here.
All right, awesome. Thank you, Scott, for all of that information. And thank you, everyone out there, for attending today's 10th episode of Coffee with Casey. I hope you found everything informative today. There were a lot of questions submitted that I'm sorry we didn't get a chance to answer live, but you will hear from either myself or Scott with the response to your question. And here's also our contact information. If you think of any additional questions after you've had some more coffee and had some time to think on today's topics. As a reminder, everyone will get a recording of today's webinar along with the PowerPoint presentation. And if you could please fill out the survey and let us know what you thought of today's session. If you have any ideas for future topics, we'd love to hear them. And thanks everyone again for attending. We appreciate it. Thank you so much. Have a great day.
Thank you. And thank you, Casey.
Yes, thank you, Scott. Bye.
Bye-bye.